because the rules of evidence don't apply to bond reductions. Am I incorrect?
Well, I think for someone, my position that is that someone would have to be the person that they would present the evidence. Just by, I can put in a encyclopedia and say, well, just look at this. Someone would need to be able to make the correct profit. I don't make the correct profit.
Okay. All right. The objection will be overruled and the court will will review State's Exhibit number 1 just for purposes of this hearing. And if y'all will step back while I read this. All right. The court has read State's Exhibit number 1. And Mr. Camarillo, the court is reading State's Exhibit number 1 really for the sole purpose of making a determination on what your bond should be set at. That will ensure the safety of the community and also ensure that you appear at court.
Yes, John.
That's what this entire hearing about. The State's Exhibit number 1 is not for me to review it in light of does the state prove its case beyond a reasonable doubt? Because that's something where witnesses will be called and your attorney can make objections and you may have hearsay objections and other type of objections. So this is strictly for me to review that, take in consideration the testimony of your mother and decide what your bond should be set at. Do you understand?
Yes, ma'am.
So I've reviewed the documents, I've heard the testimony, and the court will hear argument on bond requests.
This is my motion that I waive and reserve to close.
All right, so we're back on the record. In 2025 CR 006058A, State versus Dorian Camarillo. The parties re-announced.
Megan Galloway for the state.
Cornelius Scott for the defendant.
All right, and so we were proceeding with closing arguments and the defense had reserved their closing. You may proceed, counsel.
Judge, one thing I noticed most times when the state make their positions on bond, they go, if the person has a prior record, that's one of the first things that we hear. Nothing, silent. Kind doesn't have a prior record. Secondly, it appears that when the original bond was set in this case, the original charge was capital murder. That charge has been reduced. Because as everyone knows, capital murder would be, if you were convicted, it would be life without parole or possibly the death penalty. Not in his case because of his years. So we're not talking about those type of situations. We're actually talking about a first degree. So what I'm asking the court to do in this case is set the bond, which is typically set in a case where there's a first degree. Now, the state proper State Exhibit number 1 in even in that proffer, it doesn't suggest that my client died anyone or urged anybody to do that. It appears that the person that is deceased was a person that was allegedly in a vehicle, and it never an indication that my client at all did anything in terms of physically to harm this person. It appears that the perhaps the victim in alleged aggravated robbery actually shot and killed.
So is this is one of those cases, I believe, where you have the alleged defendants in a vehicle and the complainant is alleged to have shot one of the people in the vehicles, but it's also alleged that it was in the process of persons in the vehicle committing an offense. That's one of those Texas rules. Murder, yes.
So you have to do a lot of twisting and turning and maneuvering in terms of understanding. So my position, Judge, is that if it's murder case, first degree, at this point, we just want the bond set where a first degree case would normally be set. And my position is that that is typically around the $100,000 mark, maybe up to $150,000 mark. I'm just asking the court we have a young man who's still in high school, to set it at somewhere in that area, even if the court needs the assurance of electronic monitor, to have it monitored at all times, and that's fine. That's understandable. We just feel that to keep it, if the state reduces the charge, just with the court, the magistrate originally set it at $500,000 based on the allegations of a capital murder. And that case is reduced, then we just feel that the bond should be reduced to what is typical in a first degree situation. And that's all we're asking for, something that's in that.
Okay. All right. So what I can tell parties, and I want to make sure it's clear, because on what I have on the docket sheet, it says capital murder. So it's no longer listed as a capital murder. Is that correct?
That's great.
That's the indictment. Felony murder and count 2 aggravated.
All right. Anything else to put?
No.
And as a condition of his probation, as a condition of his bond, is one of his conditions already for GPS or no?
Well, the copy that I have, it was a blank copy. So, but I would imagine that it would be GPS.
All right, let me just, I'm trying to look up his conditions of bond. It's not in my system. I don't have that in my Odyssey, at least what I have access to.
When I look at the notes on the viewing of the defendant, it says GPS full house arrest, no contact with the family and paid in full, no firearms, and random drug / alcohol test.
Okay. All right, this is what the court will do. Okay. All right, what I can say is based upon what the court has read and states exhibit number 1, and state, is it correct that this defendant does not have any prior cases? All right, so based upon what the court is reading in states exhibit number 1, based upon the evidence that has been tendered, in just one moment. All right, this is what the court is going to do. Court is going to set the bond at $250,000 with all previous conditions.